Welcome. Today, we're going to tackle a really tough but super important question that a lot of people face after a workplace injury here in Scotland. It's a situation that can feel pretty overwhelming, but as we're about to see, there are definitely clear paths forward.
Okay, so let's just dive right in. Imagine this. You've been diagnosed with an industrial disease, maybe, or you're dealing with an old injury, and you go to look for your former employer, and they're gone. Bust, dissolved, vanished. That moment can be a real gut punch.
And yeah, that feeling of hopelessness is completely understandable, isn't it? You're already trying to manage a health issue, and now it looks like the door to any kind of compensation has just been slammed shut. This happens all the time with diseases like asbestosis, where the job might have been decades in the past. But I really want to make this crystal clear, and if you take one thing away from this, let it be this. It is not the end of the road. The most crucial point is that the law in Scotland actually has multiple ways for you to get compensation, even when the company that caused the harm is long gone.
So how on earth does that work? Well, the whole system, the whole reason this is possible, is built on one single really powerful idea: the insurance policy.
It all goes back to this law from 1969. You see, this act basically forces almost every single employer to have a special type of insurance. It was designed from the ground up to be a fundamental protection for workers, one that was built to outlast any individual company.
And we're not talking about some small token policy. The minimum amount of cover required is £5 million. That's a huge fund, specifically set aside to make sure that people with valid claims can get paid. This slide just illustrates the idea perfectly, doesn't it? The company can crumble to dust. Its building sold, its name erased. But that insurance policy, that legal contract, it survives. The insurance company's obligation to you is still very much alive.
Okay, so great news. The policy exists somewhere. But how in the world do you find it? Especially if it was taken out 50 years ago by a company that's now just a memory. Well, this is where the detective work really begins.
The main tool in the toolbox for this hunt is the Employer's Liability Tracing Office, or ELTO. Just think of it like a giant central library for insurance policies. A good solicitor can search this database and hopefully find the insurer, the policy number, everything they need.
Now, it's important to note that ELTO, as amazing as it is, isn't a perfect time machine. Records can have gaps, and that is exactly why having a specialist solicitor is so critical. They know all the other places to look, like digging through old records at company's house when the database comes up empty. Right, so once the insurer has been found, you need another legal key. You can't just, ring them up and ask for compensation. You need a specific law that lets you open that door and make your claim directly to them. And here it is. This act from 2010 is an absolute game changer. Before this law, the process was a nightmare. You often had to go to court just to get the old company put back on the official register. This act just sweeps all that hassle aside and lets you go straight to the source, the insurer. But what about those really, really tough cases? What happens if, after all that detective work, the insurer just can't be found? Or what if you find them, only to discover that they've gone bust too? Well, the thing to remember is that even in those worst-case scenarios, you're still not necessarily out of options. There's a whole network of government-backed safety nets. These are official schemes designed to step in as a last resort when the normal route is completely blocked. And here are the main ones. You've got the FSCS, which helps out when an insurance company itself has failed. And for really specific diseases like mesothelioma or asbestosis, there are dedicated schemes that can provide lump sum payments when there's literally no one else to claim from. So we've gone through the legal bits and the safety nets. Knowing all this is one thing, but actually taking quick, decisive action is what's going to make all the difference. The very first thing you need to know is the time limit. And this number, it's so important. In Scotland, you generally have 3 years to make a personal injury claim. And discovering your employer is gone does not stop that clock. It just keeps on ticking. Now, when it comes to industrial diseases, there's this really important idea called the date of knowledge. What it means is the 3-year clock doesn't start from your last day on the job. It starts from the moment you became aware that, 1, you have a serious condition, and 2, that it was probably caused by that old job. So, what's the takeaway from all of this? 2 clear, practical steps. First, find a solicitor who lives and breathes this complex stuff. Their experience is absolutely priceless. Second, start digging. Gather every single piece of paper you can find about that old job. Any little detail could be the key that unlocks the whole case. And let's just end on this thought. It perfectly sums up this whole thing. Yes, it's going to be more complicated than a standard claim. It takes real expertise. But the system is designed to get justice for people. The path might be winding, but it does exist. A dissolved employer is just an obstacle, not a dead end.